Okay, greetings everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you tonight to continue with last night's video with what's his name, Brendan Joe, and we're gonna do another video of his tonight on credit discharge. But before we get into it, I wanted to go over another UCC code that I forgot to bring up in last night's video. So we're going to go over that real quick. And it's UCC 1-308. If you guys remember, I've got 11 cases down at the local courthouse I signed with UCC 1-308 and then never showed up in court. Now, these are tickets and citations from 8, 9, 10 years ago, prior to my last case of possession of sixth offense 7 years ago that extended from a, quote, not having private plates on my truck. And those cases, despite everything that's gone on since, have never come up again. They placed him in a disposition of guilty and have fines and everything shown on them, but they've never issued any warrants or anything. So under UCC 1-308, it clearly says performance or acceptance under reservation of rights. And it says a party with the explicit reservation of rights performs or promises performance or assents to performance in a manner demanded or offered by the other party does not thereby prejudice the rights reserved. Such words as without prejudice, under protest, or the like are sufficient. Subsection B says subsection A does not apply to an accord and satisfaction. Now, a brief explanation by myself. You guys should be looking this up, accord and satisfaction. What is accord and satisfaction? But I'll tell you myself, what it is when you've got a contract that's already in play and you go back and amend that contract, that is placing accord and satisfaction. You're changing the contract from its original form. Okay? That's what they mean by performance. Form, ants, the original form, or acceptance of the alterations. Okay? And that goes to dishonoring an instrument that's offered and your ability to highlight or line item veto and overwrite things to make it beneficial to you. When you see these contracts and you find out that they're not beneficial to you, you have to be able to amend them and change them, and that would be an amendment to an insurance policy whereby without prejudice or without recourse, paid to the order of. That's explicitly, as we saw yesterday, meaning that you're not taking on any liabilities. That's an amendment to an insurance contract. Oops. So pay attention, folks. The next one I want to go over is the GPO, Government Publishing Office Style Manual. Government Publishing Office Style Manual. And it says an official guide to the form and style of federal government publishing. While recognizing that federal government, as we've discussed in the past, literally means under 5 CFR 575.102 says federal government means all entities of the government of the United States, including the United States Postal Service and the Postal Regulatory Commission. Now, the commission is on the Admiralty side as a military unit. That's why it says commission. And the United States Postal Service is on the maritime side, and they are the registered agent. Okay? Those places are already formatted. It's already a contract in form. Okay? They're the ones that make the judicial regulations. So let's take a look at this. First, we're going to go down. We're going to see, let's see here. Of course, it's got all of its official notices, also known as GPO style manual. It's the official guide to form and style of federal government publications. Got the ISBN numbers, LCCN, all this stuff. You can look all this stuff up and see the sources and authorities. Okay? Now remember, we're always talking about the Paperwork Reduction Act. There's your public law for it. And it's under Title 44, Section 1105, Form and Style of Work for Departments. And I want to note here departments, as in I've mentioned 5 U.S.C. 301 in its departmental regulations. And it talks about the plain writing and minimum requirements for birth registrations applicable to Department of Defense. Okay? And let me drop this link to this PDF so everybody can have this. And there you have it down in the chat for everybody. And of course, folks, the StreamYard link is there for anybody who wants to join the panel. And again, it's the director telling you guys they use succinct words, and it's called giving a directive. So let's go down. The GPO style manual, as it is popularly known, is issued under the authority of Section 1105 of Title 44 of the U.S. Code, which requires the director of the GPO to determine the form and style in which the printing ordered by the department is executed, having proper regard to the economy, workmanship, and purposes. That's the intent for which the work is needed. It's not supposed to be voluntary. It's supposed to be needed. It's supposed to be deemed necessary. And they can only take private property of private persons by military necessity. And they must be compensated according to the fair market values and any losses that they might suffer due to that taking. The manual is prepared by the GPO Style Board, composed of proofreading. The very first duty that you have in anything you look at in a document is to proofread it. That's why I tell you to learn the concise English again. Learn how things are supposed to be composed and go back to the beginnings. The first GPO style manual appeared in 1894. It was developed originally as a printer style book to standardize word and type treatment. And they indoctrinated you into treating those words in a different way than they're meant to be used, different than their intent. And it remains so today. Through successive editions, however, the manual has come to be widely recognized by writers and editors, both within and outside the federal government, as one of the most useful resources in the editorial arsenal. Now we're going to go on. We're going to take a look at some other things along the way here, particularly when it comes to the proofreading. They even give you advice. And here we go. Corrections made to proof should be indicated as follows. So when you get those documents, you can use this to correct them, folks. The more you learn how this stuff is supposed to be constructed and show that they don't know what they're doing, then the better you're going to be able to prove the inconsistencies and impossibilities that they place in those documents. And thereby, if they give you an offer, you have the ability and the right and responsibility to correct them. They even show you a thing of how you'd correct something using all those things with notes on the side. So let's take a look. The thing I'm interested in is a thing called Allmark. I've spoken on this before, and it goes with that signature in how it is aligned. When the Allmark and signature or the imprint and signature appear on the same page, the signature line is placed below the Allmark or imprint. So they give you the Allmark. You saw that in yesterday's video. The Allmark on that was a stamp, an imprint, which is considered a signature, and then they signed on it, that line. But above it was the Allmark. Okay? On my documents, this is known as an Allmark. It's a parenthesis with what looks like to be an O, but you can obviously see it's different than an O in some way, shape, or form. I have yet to figure that out. I don't know what text style that is, but it looks like an O. And on the financial index that I got from the local courts about all those cases, that's exactly how the obligor starts out with. Starts out with a parenthesis, the O, and then an end parenthesis, and then it says BLIGOR. So it's got an Allmark in the description, the symbolic symbol string of data elements that we see as obligor, and it's got an Allmark to start it. Okay? The Allmark is placed below the page, bulletin, or circular number, but above the signature line if both appear on the same page. So that is literally describing that stamp that we saw that they use when you sign, and then they put a stamp on it, and then there's another signature line. So let's take a look at the next one. And before we get into the video on credit, I've got one video. If you guys have seen me talking about Tiffany Henyard of Dolton, Illinois, the mayor over there and city leader of another town or something. I don't know how she's got the two titles, but quite corrupt. And just not too long ago, she pulled another stunt. And this is communism. This is straight up communism. This is treason. This is sedition. I am not afraid to make those comments. I'm not afraid to state my opinion out there. And if that little bitch wants to sit down with me and any and all of her lawyers, attorneys, God almighty, strike that fucking bitch down. This is enough, people. It's time to put these people in their place. And that's what we're going to go over after we see this credit video.
So crazy when I arrived here Friday and saw the blocks.
A South Suburban car show is canceled after the entrance is barricaded with giant concrete blocks.
Now, the sponsor of that show and the Park District are calling it an act of revenge by the mayor in Dalton, Tiffany Henyard.
Dane Placco reports the Park District is now considering a lawsuit against the mayor.
Always a good time for everybody that comes out, fun, exciting.
good for the community.
For the past 8 years, Darren Bosley has organized an annual car show here in the parking lot of Needles Park in Dalton. But after paying $1,000 to the Park District for this year's permit, Bosley got an unexpected call last Wednesday from Dalton Mayor Tiffany Henyard's top assistant,
saying that the show would be shut down, but if I move my event to her location on Greenwood, that I will be fine.
Did you take that as a threat?
Yes, I took that as bullying.
Sure enough, when Bosley showed up at the park Saturday morning, he found that giant concrete barricades had been placed at the entrance, and Dalton police were threatening to tow any cars that parked there.
We talking about two different governments. We're talking about the park government versus the village government.
Dalton Park District President Cleo Jones says Mayor Henyard has no legal authority over Park District property and believes she didn't want the competition to hurt attendance at her own event, a house music festival a few blocks away.
So I'm not sure what her tactics were other than trying to bully us and push us away, but that's not going to happen here.
We are walking all over cancer on our way to Springfield.
Henyard is no stranger to controversy. Fox 32 recently reported how Henyard used village employees and funds to pay for a march to Springfield to support a charity in her name. What would you say to the mayor about this?
Get your life together, get your act together. This is wrong for people that spend money with the Park District to try to throw an event, peaceful event, fine event, and it's good for the community, but you're taking that away from everybody.
We left.
Absolutely. Absolutely. And what it is interference with commerce. Those people spent money to hold an event so that they could advertise or gather socially and educate, whatever. It was interference with commerce because they paid for the event. Now, when we think about interference with commerce, that's 18 U.S. Code 1951, interference with commerce by threats or violence. Whoever in any way or degree obstructs, delays, or affects commerce or the movement of any article or commodity in commerce by robbery or extortion, or attempts to conspire to do, or commits or threatens physical violence to any person or property in furtherance of a plan or purpose to do anything in violation of this section shall be fined under this title or prison not more than 20 years or both. So what I want to tell you is everybody that's involved in that, all the police that are involved in blocking that off, the people that put the blocks there were hired to do so. These people are doing public service, and in their heart, they're just doing their job. And that's the problem. These people are not acting in equity. They are acting in complete communism. And again, if you have any problem with me saying that, then please come join the panel. Because I assure you, there are many people in this world that will agree. This is straight up treason and sedition. And these people need to be put away. And we'll see some even better ones later. Because again, this has to do with public servants and them doing what they're directed to. And the directives are already there. So let's take a look at the next video. This is our brother we watched last night.
You're listening to the Wired for Impact podcast.
If you wanted something that...
And this, I'm telling you what, guys, this is a very intelligent young man, and I hope you go over and check out his channel. I'll grab his link again, and you can go check him out. Make sure this is the one I want. No, this is Wired for Impact, but I'll get his channel up for you and drop that again.
That you can use for credit related transactions. In my opinion, one of the most powerful U.S. code is 15 U.S.C. 1601. Basically, what this one says is that Congress is saying that you have the right to ask any question and understand any of the terms or any of the words or anything associated with any disclosure of credit related activities. So when you start asking about negotiable instruments or coupon payments or set-offs or any of these kind of things, you'll start finding that people are very weirded out by it and they don't really understand it and this and that, you can use 15 USC 1601 and say, hey, guys, I have the right to understand this. If you look up the American Express terms and conditions, nobody ever reads any of their terms and conditions or their card member.
And that's the problem. Again, folks, when I got that sales agreement at the local emergency room at the hospital, I read it. Most people don't do that. That's part of the problem. How are you going to proofread it and make sure that it's beneficial to you if you don't first read it?
Member agreement. If you look inside the card member agreement for Amex, go into your online bill pay or whatever, and there'll be a section and you can click on download card member agreement, right? It's not, once you go through my course and stuff like that, it's not terribly difficult to read. You're going to go down to the section that says how to make payments, which is on page number 2 of 10. And it says here, how
to make payments.
To make payments.
Does that tell you you're the one that's the maker? What's a maker? A creator. You're the one that's actually making it. They created a form, gave it to you in draft, and now you are going to make directives on it if you know what to do. You are the maker. Learn it, believe it, know it, live it.
And it says here, when making a payment by mail, there's a few bubbles. And bubble number 3 literally says, write the account number on your check or negotiable instrument and include the payment coupon.
So, do you have to give a name and address? Again, nowhere does it tell you have to give a name and address. And in every case, it will show you in like wording, yeah, you can give a number.
It literally says that right in the fucking card member agreement. So you think to yourself like, okay, the card member agreement says that I can pay with a negotiable instrument. And then you say to yourself, okay, 15 USC 1601 gives me the right to ask absolutely any questions that I need so I can understand my credit agreement. They don't have the right to not answer your questions. Did
you hear that? Do you understand that? All you have to do is be peaceful and just ask questions. That way, when you have the information and you know and there's something wrong, that's when you start asking questions. That's an information pathway. That's how you educate these people. You ask them questions. Well, this says here, this. What is the definition of this as opposed to that? This more suits me. Can we use that? Da 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 da. It's a negotiation, not a battle. You are no longer in a fight. You are negotiating so you can end the fight. That is the correction of the records. You are not supposed to be in a battle of the forms. But that doesn't mean that you can't use them. Once you learn how they're used, it no longer becomes a battle. It becomes negotiations.
They have to. Congress has commanded that anything you want to ask, they have to answer. Now, people will say, oh, I'm going to use this and I'm going to get on the phone and I'm going to fucking crush these fucking people, blah, blah, blah. Well, okay. You want to be a fucking dick about it. What's stopping them from just hanging up on you? What are you going to do about it? Are you going to file a lawsuit and push and push and push and take the lawsuit all the way to a trial by jury because you're upset that they're not following what Congress has stated? If you are, then fine. If you're not, don't be a fucking dick. Because if you're a fucking dick, that's what you're going to have to fucking do.
Yeah. See, he's saying the same thing I am. And you guys know me. I am the whole ass. When it comes to truth, I am the whole ass. But when it comes to asking questions on paper or making statements on paper, it doesn't come through with the emotions.
So you have to ask yourself, am I willing to do that? If the answer is yes, then be a fucking asshole about it. I don't care. 15 U.S.C. 1601. You have to answer my questions, motherfucker, blah, blah, blah. Okay, get ready to start in small claims court, to do an appeal, to work your way up to a fucking trial by jury, set a date for a trial by jury. And by that point, I guarantee you the credit company is going to acquiesce and they're going to do whatever you want by that point because they don't want.
And this is the same thing. When you practice this stuff and you get better at it, the better you get at it, the more you're going to do it. The more you do it, the better you get at it. And at a certain point, you're just going to be able to do it in writing and not have to even get upset about it. It's a matter of just placing the facts on the record. Say, well, like that medical associate says, well, you didn't put any value in here, so I accept it for the zero value that it has. If you have any questions or concerns, make sure you file a postal docket in the postal court and give diplomatic service of notice. They already know the directive is already there, so you use those directives in plain language in your notices and private letters. It's already there. It's common sense. It's plain language. As we've been seeing, it concurs throughout the jurisdictions, like wording, without recourse, okay, without prejudice. UCC 1-308. But you better be able to back it up with more than just that. You have to learn all this stuff, and I'm telling you, it's a hell of a lot to learn. But I guarantee you, if you don't, you're going to condemn your children to these contracts without knowing what they're doing.
A bunch of people in a room talking about negotiable instruments and coupon payments. Okay.
Right.
So you have to think to yourself, okay, if you're kind of new to all this information, chances are you're probably not going to be ready to go down that road. So you have option B. Option B is to be very kind and to be very understanding and to create a relationship and to ask questions and just say, look, I've been digging around on this. I'm reading the card member agreement. I found 15 U.S.C. 1601 that states that, I just want to get some questions answered. I just want to understand my credit agreement. Who can I speak to? Can I speak to a supervisor or someone that can help me understand my card member agreement? Now,
and again, this goes to their obligation to assist you. American Citizens Assistance Service. Remember we spoke about that a few nights ago. They can't deny you. They have prohibitions of excluding anybody due to national origin. They have to assist you.
Ideally, you do all this while you're still making your payments. You just keep making your payments with Federal Reserve notes. The account's not in collections. The account's not late. The account's not fucked. You're just calling as a completely normal consumer with a completely normal account, asking some questions about the account that you have that you're paying and current on.
Mm-hmm.
What are they going to do? They can't do anything else. It's like, okay, like we need to find somebody who can answer this guy's questions, right? So that's the way I'm going to be doing it. I'm still at the very, very tail end of just making sure I completely understand all of this. But essentially, as of this last week, I've come to a lot of new realizations about all of this, which is a lot of what I'm actually speaking about brand new information that's just come out like days ago.
Mm-hmm.
And this is kind of like the path that I'm going to be walking. And I know for sure, for a fact, this is a path to make this happen for people who want to make this happen. But a lot of people just send in a coupon payment or a negotiable instrument and it gets ignored, or they get a denial letter and then they just give up. Right. And the thing is,
now he's going to make a very valid point here. Remember Isaiah 22:22, and the key of the house of David I shall lay upon his shoulder, and he shall open, and no one shall shut, and he shall shut, and no one shall open. Pay attention.
Is that's the people that you're sending these things into don't understand any of this, even though it is in the card member agreement. They don't ever see it because there's almost nobody that knows any of this information, right?
Mm-hmm.
So you have to be ready to you know, the big misunderstanding that people have that makes them so fucking angry is they think the person on the other end of the phone or the other end of the letter means them harm. And they don't,
and that they know, and they're
harm.
withholding it from them, and
Exactly. And
Yeah.
they get all fucking butthurt and angry about it. That's not true, man. There is very, very few people that have any clue about any of this.
I think this is really part of the quote unquote Great Awakening. And if we look at it from that perspective, it's like, oh shit, I've been asleep this whole time. I didn't realize this was out there. I'm now discovering that there's these things. I'm kind of fumbling around, figuring it out. I'm politely saying, hey, I'm just looking at your own definitions and your own words and our own agreement. Doesn't this mean this and this mean this? Help me understand that. Oh, it does mean that. Okay, cool. Thank you so much. Like, let's just all wake up together politely, kindly, serving each other, and let's all wake up to, like, we don't have to have a massive conflict. It doesn't have to be that way. We can do it in a way that's you know, kind and peaceful.
Yeah, and think about it. When you're
essentially.
talking to somebody over the phone, even if you're talking to a phone person at American Express, shit, man. I mean, they have just as much right to send in negotiable instruments on their Amex account as you do.
Exactly.
So
I've
who's to
seen these
say who's to say that you call in and you talk to these people and they're not blown away and they don't look at, just say, oh, excuse me, what was your name again? Oh, Liliana. Oh, Liliana. So I'm looking at the card member agreement, page 2, under how to send in payment by mail, bubble number 3. Do you see that there? Do you see it says about how I can send in a negotiable instrument with coupon? And you just say, you know, what exactly are they referring to? Because I'm looking at Investopedia.com. It says here, a negotiable instrument is a promise to pay. So does that mean I can just send in a promise to pay? Or can I just promise to pay this bill and sign it and send that in, and that'll discharge or set off the account in some way? By that point, they're going to give you a supervisor, okay? Because they don't have a fucking clue. They've never looked at the card member agreement, okay? And then you
guys hear that? That's why we have such a hard time communicating with some of these people, like he said. We think they do know, and they don't. I'm telling you, you have to come forth as the educators. Everyone has been indoctrinated.
You're just going to work your way up the line by doing that. And you're just going to ask questions. And then as soon as you get a supervisor and they start to get angry with you or something like that, you go, excuse me. My account is not delinquent. My account is fully paid. I've been a member of American Express for X amount of years, and 15 U.S.C. 1601 does state that Congress has specifically stated that if I have any questions about a credit-related agreement, I have the right to ask questions. You seem to be getting very upset right now. There is...
And remember, when they say credit agreement, remember the definition of a credit card is any card, plate, coupon book, or device used to obtain money, property, labor, or services on credit. Social Security gives you a card so that you can obtain money, property, labor, or services on credit. But again, nobody's taught you how to do that. Learn it. This is what we're going through now.
Absolutely no reason to be upset with me right now. There's nothing I have done to deserve you being upset with me right now. I pay all my bills on time. I have been late very little, or once or twice or whatever. I'm just trying to understand what's in the card member agreement. And you can say, you know what? When I first signed up for this thing, I didn't read the card member agreement. And you know what? That's my bad. But now I am. And 15 U.S.C. 1601 states that I can ask questions as regards to my card member agreement, and I can ask as many questions as I want. Okay. Now, I have some questions. Are you willing to follow 15 U.S.C. 1601? Are you willing to follow what Congress has said I have the right to do? Or would you like to grossly violate my rights right now and not do exactly what the law says that we need to be doing right now, which is to answer my questions?
And that's again the difference between arbitration and private. You're asking them if they want to keep it private and just do as we're supposed to according to the law and not act like enemies, belligerent combats and such, but actually negotiate. That's the law, folks. Negotiate.
You can get a little bit stern at that point, but you're not going to do that with fucking some Filipino that you first get that doesn't know a goddamn thing.
Yeah. It's important to remember that there's a lot of us that are asleep.
Thank you for listening to this episode of Wired for Impact. If you're interested in creating and expanding your
So we have a simple credit process, a simple qualifying special endorsement, and a way to negotiate by merely asking questions so that you can make sure that you're competent in the contracts, in the credit agreements. Almost every one of them is a credit agreement. I don't know too many that are based on actual assets anymore. So there's another one.
Welcome back to my channel.
And this is, let me see here. Fantastic. Fantastic. Let's drop that down there. And this is the video there. And she, I imagine, I haven't watched this one yet, but I imagine she's going to help explain it in a mathematical flow as it shows here. So let's take a listen.
I am Christy Van with Fantastic Finances, and I teach Velocity Banking. Today, we're going to be discussing a lady that has a zero cash flow, yet she wants to begin debt elimination. So rather than go out and pick up a pizza delivery job or any other second job or changing her lifestyle, we wanted to give her solutions that could help her begin today on getting rid of some of her debt and raising her credit score at the same time. So she has an income of $3,000, but her expenses are $3,000. So that leaves her with a zero cash flow. She has a credit card that has a $10,000 balance on it already. So it's to its limit with a $400 a month payment. Now, her rent is $1,000. And besides that, everything else she has for expenses can go on a credit card, that being her electric bill, phones, water, food, gas, and car insurance, etc. So anything that can go on a credit card, she is going to put it on it during this debt elimination of this $10,000. So the first thing that I suggested she do.
Most people have no clue that in 2023, the best way to make money on Amazon is not.
Is since she has a $10,000 balance, she will bring her income and transfer it into this line of credit instead of to her bank. So as soon as she gets paid, she will have to leave the $1,000 for her rent in the bank because credit cards cannot be used to pay rent and mortgages usually, unless you go through specific programs like P.I.G.S.C.U.N.T.S, something like that. And then the other $2,000 can go directly into this line of credit. Well, one thing that you will notice immediately, the balance on that credit card comes down. Well, what does that do to your interest? And what does that do to your credit score? Everyone knows that if you want to raise your credit score very quickly, you have to put money into those credit card balances and get them down. Every time you take down a balance, your credit score goes up, right? So this is a terrific way for her to raise her credit score really quickly and help knock out some of that interest that she's paying on this 21% credit card. Now, she automatically has everything set up where it's coming out.
And you know, back when I was a kid, that 21% interest rate was illegal. I think the cap was like 18%, and now they have people paying 28, 30%, if not more. This is getting sickening, people. You shouldn't be using those credit cards in that fashion. You shouldn't have to worry about a credit score. And one more time, if there's a credit score, where's the debt score? That's why we're going into the record and asking these questions, so we can correct that. Because if you're going to try to put a credit score on me, it better be above yours, because you're the one working for me.
Of the credit card. She will swipe her credit card when she needs gas. She will swipe her credit card when she needs food, groceries. If she has subscriptions, anything that can come off of a credit card is going to come off of this while she works on it. So when her balance comes down to $8,000, of course she's going to have $2,000 in expenses coming out. Well, not necessarily, because when she started using the credit card in this manner, guess what happened? That $400 payment went away. So what does that mean? What does that make this balance do? What happens to the credit card balance when you are satisfying this $400 a month by just putting in your income? So since she satisfied that, then her expenses to come out now will only be $1,600 because the $400 stays in there. So now when she adds this, her balance will go to $9,600. It's gradually growing back up to this $9,600, which keeps the interest low because they are figuring your interest on the average daily balance. So when she does this, and this is month 1, right? And this is month 1 expenses. Then she's going to come in month 2 and she is going to do it again. So we'll put in the $2,000, and what happened? Immediately her balance is down to $7,600. That is going down pretty fast. That's 2 months. She's already hit the $7,600. Now, yes, in her second month, those expenses are going to start coming back out again, right? But remember, this $400 is gone. Now this satisfies that payment, and she will only have the $1,600 that she needs for her expenses. Okay, so if we have the $7,600, then we add back in her $1,600 expenses that she will have for month 2, then she is back up to $9,200. So do you see how now she has a little bit of money to work with, because her balance is at $9,200 in the second month. So beginning her third month, she will do it again. So here comes her income, $2,000, immediately taking her balance down to $7,200. And there's her low balance again. So on one day, she could have the average daily balance of $7,200. That's going to look great on her credit report, better than $10,000 that she's had it standing at for about 2 years now, and she's paying all of this interest, right? So we'll do it again. Her expenses will go back in again.
Recently, and for no reason at all, I asked Mint Mobile's legal team if big wireless companies are allowed.
The month, beginning it, the 4th month, she will have an $8,800 balance. Now, this will happen every month until this card is paid off. So her balance at the beginning of $400. So in 17 and a half months, doing nothing but just putting her money into a credit card instead of letting it sit in the bank, in 17 and a half months, this is going to be paid off. The whole time she has an emergency fund building up that she doesn't have to stress out. She's keeping all of her cash flow. It's going into this card. It's not just being.
I hope you guys understand that concept, because that's what it is. It's math. If you're stuck in that situation, learn how to take care of it. And then, of course, that's only if you're stuck not knowing how to do the other stuff yet. So let's get on to the next one. We're going to start getting into these regulations and how to hold these people accountable. And the first one we're going to look at is that is a basic obligation of public service at 5 CFR 2635.101. Basic obligation of public service. And anybody working in the financial industry, accountants, tax reps, bankers, anybody, clerks, notaries, bail bonds, all of those working in those public services, these are their obligations. Now, the other entities, federal government means all entities of the government of the United States, and the United States is the corporate fiction, and they're the ones that propagate all these forms for contracting. So anybody using those forms are in government contract, like your landlords and stores and things like that have to follow by the federal regulations and stuff. Yeah. So those are all for public accommodation, they say. So in public accommodation, when we went through this mask thing, nobody understood the public accommodation meant that they amended the contract, and you had already, if you signed without qualifying, then you accepted the amended contract, taking upon liabilities, which is insurance. A, public service is a public trust. Everyone in a service contract for public service of any sort is a trustee. This is important because it's under Title V, Administrative Personnel, Office of Government Ethics, Standards of Ethical Conduct for Employees of the Executive Branch. And every document you execute by putting a signature on there, that's what you're doing. You're executing things. You're acting as the executive. Each employee has a responsibility to the United States government and its citizens to place loyalty to the Constitution, laws, and ethical principles above private gain. To ensure, much like endorse and endorse, ensure that every citizen can have complete confidence with fidelity. Confidence with fidelity. A fidelity agreement, much like a peace treaty. In the integrity, the enumeration, integral, integer, integrity of the federal government, each employee shall respect and adhere to the principles of ethical conduct set forth in this section, as well as the implementing standards contained in this part and supplemental agency regulations. So before we get on to employee, I want to remind everybody what implementing is. Contract terms and conditions required to implement statutes or executive orders, commercial items, commercial products. Everybody with me still? So let's look at employee before we go on farther. Employee of an agency, including a special government employee. Did you know when you're born and they set you up at that enumeration at birth under Social Security, you're qualified as a Medicare qualified government employee? Ask them. It includes officers, but not enlisted members of the uniformed services. It includes employees of a state or local government or other organization who are serving on detail to an agency. That's why you got to learn those data elements are the details that you're giving them. They're looking for the details, the height, weight, eye color, hair color, data. You're giving them details. Pursuant to Section 5 U.S.C. 3371, at sequential for purposes other than subparts B and C of this part, it does not include the president or vice president. Status as an employee is unaffected by pay or leave status in the case of a special government employee by the fact that the individual does not perform official duties on a given day. The rest is a misprint. It says the exact same thing as it does above. It says the same thing, means any officer. They printed this over again, right here. Okay? It's the same thing. Now pay attention. This part was yet reprinted again. I want everybody to pay attention here. I want to ask you, are you able to proofread? Are you able to send them a letter and let them know that, hey, you made an error? This here is a duplicate, and then this here is a triplicate of that, which is in the duplicate here. You restated it twice, and then restated this part a third time. These people are not perfect. They make mistakes. And that's all you got to do is find the mistakes in their contracting. It's their contract terms and conditions. And when you find those mistakes and say, wait a minute, that won't be beneficial to me. And in fact, it isn't beneficial for me to read this twice or three times, but rather only for the purpose of sending them a notice to let them know they need to correct this public record for its redundancy. Okay? Simple as that. There's no argument. You know, just fix it. That's all we're doing with the record. Do you understand? I hope so. So let's go back and look at the rest of this. General principles. The following general principles apply to every employee and may form the basis for the standards contained in this part. Where a situation is not covered by a standard by the standards set forth in this part, employees shall apply the principles set forth in this section in determining whether their conduct is proper. Okay? Where a situation is not covered by the standards set forth in this part, employees shall apply the principles set forth in this section in determining whether their conduct is proper. They're telling you you have to watch for yourself based on principles and not by the standards. Can you read between the lines? Can you read between the lines? The following general principles apply to every employee and may form the basis for the standards contained in this part. Where a situation is not covered by the standards set forth in this part, employees shall apply the principles set forth in this section in determining whether their conduct is proper. Public service is a public trust. Where did we hear that before? Requiring employees to place loyalty to the Constitution, the laws, and ethical principles above private gain. Employees shall not hold financial interests that conflict with conscientious performance of duty. You have to be conscientious yourself. Employees shall not engage in financial transactions using non-public government information. Or allow the improper use of such information to further any private interest. So why are you giving them your private information if you're not a public employee? An employee shall not, except as permitted by subpart B of this part, solicit or accept any gift or other item of monetary value from any person or entity seeking official action from, doing business with, or conducting activities regulated by the employee's agency, or whose interests may be substantially affected by the performance or non-performance of the employee's duties. Employees shall put forth honest effort in the performance of their duties. Goes to honorability and the honoring of an instrument. Employees shall not knowingly make unauthorized commitments or promises of any kind purporting to bind the government. Employees shall not use public office for private gain. Tiffany Henyard. Employees shall act impartially and not give preferential treatment to any private organization or individual. Employees shall protect and conserve conservation laws, federal property, the conservation easements, and shall not use it for other than authorized activities. Employees shall not engage in outside employment or activities, including seeking or negotiating for employment that conflict with official government duties and responsibilities. Employees shall disclose waste, fraud, abuse, and corruption to appropriate authorities. So if I point out that there's some kind of waste or corruption going on, because I'm not going to accuse anybody of fraud or abuse, but I can show that the record is corrupt, in error, and it's causing a waste of use of paper in violation of the Paperwork Reduction Act, then I should do so. Employees shall satisfy in good faith their obligations as citizens. So you see how the citizens are employees and employees are citizens, and they hold the same obligation. So you keep claiming that you're a citizen. Keep claiming that you're a resident. That's a lie. Including all just financial obligations, especially those such as federal, state, or local taxes that are imposed by law. Medicare qualified government employee and the assignment of Social Security number is in fact a taxpayer identification number. Again, qualifying you as a Medicare qualified government employee as a citizen of the United States based upon the conference of that nationality, which is false, and then the claim that you are a resident by the state, who has never deemed you necessary because they can't deem children necessary to the military unless they bring those children up in their own corporate company scheme as military infantry through the public education system and teach them in an indoctrinated way to fill out the battles of the form without knowing how to qualify themselves above and beyond it. Employees shall adhere to all laws and regulations that provide equal opportunity for all Americans, regardless of race, color, religion, sex, national origin, age, or handicap. How come they use handicap here instead of disability? Employees shall endeavor to avoid any actions creating the appearance that they are violating the law or the ethical standards set forth in this part. Whether particular circumstances create an appearance that the law or these standards have been violated shall be determined from the perspective of a reasonable person with knowledge of the relevant fact. You have to be a reasonable person with sound mind and logical thought process to comprehend that you made the mistakes based on your father's mistakes or your father's sins, because there is but one Father which art in heaven, and you keep paying tribute to a patronymical father as your daddy taught you to. Fix the record. You ain't my fucking daddy. Excuse my language. Related statutes. In addition to the standards of ethical conduct set forth in this part, there are conflict of interest statutes that prohibit certain conduct. Criminal conflict of interest statutes of general applicability to all employees. 18 U.S.C. 201, 203, 205, 208, 209 are summarized in the appropriate subparts of this part and must be taken into consideration in determining whether conduct is proper. Citations to other generally applicable statutes relating to employee conduct are set forth in subpart 1, and employees are further cautioned that there may be additional statutory and regulatory restrictions. Statutes and regulations are not jurisdictions in law. There are 3 jurisdictions: criminal, civil, and military tribunal. Civil and criminal is under Federal Rules of Civil Procedure, Rule 2. There is one action: civil. Everything is contract from the military down to criminal. Applicable to them generally or as employees of their specific agencies. General public. Applicable to them generally because you claim to be part of the general public and not the specific American that you were born. Because an employee is considered to be on notice of the requirements of any statute, an employee should not rely upon any description or synopsis of statutory restriction, but should refer to the statute itself and obtain the advice of an agency ethics official as needed. Okay? Now, one thing I want to point out here, when it comes to proofreading, folks, pay attention. At the top here, we have this nice little set of blue stuff that you will find on every LII-WEX Cornell Law School page for these codes, both statutes, the U.S. Code, statutes, and the Code of Federal Regulations. Okay? And you'll see this big bold part here. And then they'll go into the specifics of this particular part, right? Now, down at the bottom of every page, there's usually something right here. After they get done stating something, there's usually a public law down here. Notice there's nothing here. Okay? So when I click on this next one, which is 5 U.S. Code 5102, definitions, applications, we'll see the same thing. It says LII-WEX, it's got the top part here, and then it says 5 U.S. Code 5102 definitions, and then it goes into definitions. It tells us for the purpose of this chapter, da-da-da-da. We'll go back up and read that, but let's look all the way to the bottom. Look at that. Okay, after this last part, or subsection of this part, then they get into all the public laws and everything that support this, right? Now, before we go on and read these definitions, I'm going to go over here. I'm going to hit 18 U.S. Code 201, bribery of public officials. So when they're talking about employees in that last code that we just saw, or the code before this definition section, the bribery of public officials and witnesses. Okay, that's under the employee. 203, compensation to members of Congress, officers and others in matters affecting the government. Okay, again, we're still talking about employees. These are your associates. Congress. Have you actually had a communication with Congress, or is that bullshit? Were you really deemed necessary by the board, or is that bullshit? Is there really a United States citizen that can have a true nationality, or is that a bullshit? So we go to the next one, 18 U.S. Code 205. Now let's go back to 203 because I got to show you again. On the bottom, they show you all the public laws and everything, right? So let's go to the next one, 205. Activities of officers and employees in claims against and other matters affecting the government. Go to the bottom, and again, they've got all those nice things about the public laws and where you can find this supporting statutes and stuff for this part here. Okay? We go to the next one. 18 U.S. Code 208. Act affecting a personal financial interest. Again, we go all the way down to the bottom. All the nice statutes, codes, rules, and stuff, right? Let's go back up here because this one says acts affecting a personal financial interest. Okay? So everything you do, your actions speak louder than words. So if you're going to sign those documents and act like a public official, then keep signing them, right? Otherwise, when they offer you a form in the acceptance, make sure you qualify them by both proofreading, line item veto and overriding, and then qualifying the signature appropriately, because that is, in effect, a device used to obtain money, property, labor, or services on credit. No money involved. Don't you get it? The next one. This is 209, salary of government officials and employees. Notice how every one of them talked about government and employees except 208, and that spoke about acts. Your actions, if they're similar and look like you're doing the same thing, like doing a banking transaction, whether you're on the teller side or on the other side, you're still acting like a banker. And again, got all the nice public laws and everything to support it. So back to this other one that doesn't. I question that. So let's go back to definitions under 5 U.S.C. 5102. For the purposes of this chapter, agency means an executive agency, Library of Congress. That nationality is meant to be entered into the National Archives when you die. Botanic Garden, the Government Publishing Office, the Office of the Architect of the Capitol, the Government of the District of Columbia. What's the difference between the Government of the District of Columbia and the Government of the United States? But does not include a controlled corporation. You are such a controlled corporation. It's known as a dummy corporation, and that is the subrogation of usufruct. The government is supposed to be the dummy corporation, but they gave you a nice little card and you're acting like the government dummy corporation because you don't know no better. Tennessee Valley Authority, Virgin Islands Atomic Energy Commission, Central Intelligence Agency, the National Security Agency, Department of Defense. Because they're the head agency, the head office, they're the head people. The Government Accountability Office, the Office of Director of National Intelligence. The Defense Intelligence Agency, Department of Defense. The National Geospatial Intelligence Agency, Department of Defense. Employee means an individual employed in or under an agency. Every last one of those corporations has a tax agent. That's an agency. It's a taxing entity. And they want that social security number as a taxpayer identification to convince you that you are obligated to pay taxes when that is voluntary. Position means the work consisting of the duties and responsibilities assignable to an employee. And this is what they're doing in those administrative courts of personnel known as individuals in the deposition hearings. They call them depositions. It's deposition. They just depositioned you. You were depositioned when you were born. You were born in a spell of illness. Class or class of positions includes all positions. Bend over, bitch! Which are sufficiently similar as to kind of subject matter of work. You know, the subject matter in them court proceedings for administrative personnel. Level of difficulty and responsibility and qualification requirements of the work. You are not qualified. In fact, you were pre-qualified at birth, and nobody rebutted it anywhere along your entire life. None. If you're a government employer, not a private sector employer, you may have Medicare qualified government employees. Note that a Medicare qualified government employee's wages and tips are subject to withholding only. You gave them that Social Security number. And you can go down to the Social Security Administration and just say, hey, I want to apply for Social Security disabilities. I'm having some psychological issues. And they'll give you an appointment to sit down and talk to them about it and give them information. And then you ask them for a report on it, your case file. Can I get a copy of my case file on this so I can, give it to my attorney or whoever I need to in this? And they're going to give you a case file on it. On that case file, you're going to see MQGR or GE, Medicare Qualified Government Employee. And it's in the Social Security Act as well. So let's take a look. to warrant similar treatment in personnel and pay administration. To warrant similar treatment in personnel and pay administration. If you want to be subject to be given orders, you will sign up for it. If you don't want to be subject to be given orders, but rather to learn how to give directives, then you should seek a higher education, not a public indoctrination education provided by propaganda. Let's take a look at the next one. We already showed you the 18 U.S. Code bribery and all that. So the next one I want to show you is that 15 U.S. Code 1601, Congressional Findings and Declaration of Purpose. Informed use of credit. They cannot exclude you from using credit. Quit falling to the falsity that you are a debtor when you have a viable use of credit. You have to understand how to change your actions so that the merits of your actions will show your spiritual credit. When you put that out, it will return. Quit trying to sue these people. Learn how to contract and prevent any suits by qualifying the information for full indemnification and forgiveness, and then qualify that signature so that each party gets equal consideration and equal benefit of the use of credit. The Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. I'm going to read that again, and then I'm going to read it a third time. Please allow it to sink in. The Congress finds that economic stabilization would be enhanced and the competition among various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. Notice it's highlighted, blue lighted, or blue underlined, blue highlighted. The term credit means the right granted by a creditor to a debtor to defer payment of debt or to incur debt and defer its payment. Why is everybody demanding payment if you can defer payment of the debt? Anybody know? Let's go back. And for the third time, the Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof, by consumers. It is the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. Even though you have a sales agreement, excuse me, I'm wording that wrong. Even though you may not have a credit card, a sales agreement is a credit agreement. And so when they send you a bill, that would be a credit billing. So it's not just limited to credit card practices. It's credit billing and credit agreements. Terms of personal property leases. This is the personal services that you keep leasing. Remember, folks, I told you the last time I walked out of jail, they tried telling me, I need you to sign this release paperwork. And it's literally said on the top of it, release paperwork. And that's what it clicks. It clicks when you see this stuff and you see how it's working. They wanted me to release my personal services to keep signing documents. Once I let them know I was no longer going to sign their documents, they understood. And now I've spent 7+ years doing the research on it. And now I'm ready to get out and start stamping certain things and putting qualified signatures on negotiable instruments. So again, I won't sign their documents. I'll give them a stamp that they can take as a signature, but that stamp is going to have qualified information to let them know that signature is a little bit different than what you expected, isn't it? Congress also finds that there has been a recent trend toward leasing automobiles and other durable goods for consumer use as an alternative to installment credit sales, and that these leases have been offered without adequate cost disclosures. You know, like Tiffany Henyard and that $149,000 some odd dollar Tahoe, right? It is the purpose of this subchapter to assure a meaningful disclosure of terms of leases of personal property for personal, family, or household purposes, so as to enable the lessee to compare more readily the various lease terms available to him, limit balloon payments in consumer leasing, enable comparison of lease terms with credit terms where appropriate, and to assure meaningful and accurate disclosures of lease terms in advertisements. And again, you see those nice little public laws. The next one, 18 U.S. Code 657. And again, it's not a matter of making accusations, but asking them questions and letting them be aware by asking questions. Well, isn't that a 30-year sentence? Huh? What do you mean? Well, if you're going to be falsifying something or anything, it says right here, whoever being an officer, agent, or employee of connected in any capacity with the Federal Deposit Insurance Corporation, National Credit Union Administration, any Federal Home Loan Bank, the Federal Housing Finance Agency, Farm Credit Administration, Department of Housing and Urban Development, Federal Crop Insurance Corporation, Secretary of Agriculture, acting through the Farmers Home Administration, or successor agency, the Rural Development Administration or successor agency, or the Farm Credit Insurance Corporation, a farm credit bank, a bank for cooperatives, or any lending, mortgage, insurance, credit, or savings and loan corporation or association authorized or acting under the laws of the United States, or any institution other than an uninsured or other than an insured bank as defined in section 656, the accounts of which are insured by the Federal Deposit Insurance Corporation or by the National Credit Union Administration Board, or any small business investment company or any community development financial institution receiving financial assistance under the Regal Community Development and Regulatory Improvement Act of 1994, and whoever, being a receiver of any such institution, or agent or employee of the receiver, embezzles, abstracts, purloins, or willfully misapplies any monies, funds, credits, securities, or other things of value belonging to such institution, or pledged or otherwise entrusted to its care, shall be fined not more than $1 million or imprisoned not more than 30 years, or both. But if the amount or value embezzled, extracted, purloined, or misapplied does not exceed 1,000, he shall be fined under this title or imprisoned not more than 1 year, or both. So you merely ask them questions that will help educate them. Are you familiar that what you're doing here by misapplying the term resident is a 30-year sentence? Or 1 year, in this lease, if you want me to sign a lease that I'm paying $650 a month, 2 months puts you over that, so that second month is going to put you to a 30-year sentence. So we really have to think about this. Rebecca, wrong one. Harry Knight, is the signature doing something other than accepting, trying to untangle this? Go back and watch last night's video on qualified signature. You have to learn how to qualify your signature, pay to the order of, without recourse, without recourse, and then your all upper caps name, and then a by and a signature line, your signature, Keith Little, benefactor. Learn how to qualify it. And there's more than one way you can qualify this stuff. Again, the 11 citations I signed with UCC 1-308. And there's all kinds of people out there saying, well, you can't just sign a UCC 1-308. That's not doing anything. It does. It's relevant to the UCC 1-308 points out a code. In that code, it says like wording. So I can tell them at any point in time, my yea be my yea, my nay be my nay. Orally speaking, I can tell them, hey, this is what it means. I reserve all rights without recourse, without prejudice. I stand under God's rights. I don't subject myself to your civilian rights. I qualify them. Okay, explain to them what my way is then. Keith's way is a dishonor under commercial law, to accept their terms and conditions and be able to veto, line item veto, and strike through them and write in the correct terms so that they don't misapply the terms in the lease. So when a lease tries to call somebody a resident, occupant, you, your. Let's look up you and your. Let's make sure, since they wanted to put the quotes around you and your, let's look up you and your. And it's funny how you and your is under 20 CFR employee benefits. So come on up, Harry. Again, I'm going to drop the link for anybody who wants to come up and join. No, signature is not a dishonor. You can use a number for the signature in case you didn't get it. Go back and listen to the beginning of the video, you nutcake. Or come up on panel and let's discuss it, because we can certainly review it. A buyer or a seller can use a widely recognized, commercially identifiable number in lieu of the name and address. And so if you can use a number in lieu of the name and address and they want a signature, it doesn't have to be the name, it can be the number. So let's get on to it. What were we going for? And of course, I do disagree. Because again, you sit here and profess that you're doing this shit and ain't done a fucking thing. And I'm sitting here showing people how I'm doing it. Again, pay attention, sucker. The sales agreement from the local hospital. Sales agreement right in it. It says sales agreement, but we know it to be a credit agreement because it uses the term credit. So let's take a look again, folks. The customer agrees to pay the stated price for the equipment, it being understood that credit will be given to the customer's account for payments received from any medical insurance program or from any third party. So if I've worked on my ass, or worked my ass all my life and paid into Social Security, and they've established insurance credits deposited in that account, and now they're obligated to give credit if they haven't, as a financial institution or depository institution on which they're primarily liable, then they'll take my directive and do as they're told. Greetings, Kingfish. Hello? Kingfish, are you with me? Guess he didn't want to stay. So, till you guys understand the terms and conditions that are already written in there to your advantage and recognize them, or learn that it's not to your advantage and be able to correct it, there's not really much you're going to be able to do except accept their dishonor in accord and satisfaction because they switched up contract terms and conditions on you. So let's get back at it. As we see there, there's all them public laws again, right? Every last one of those codes has these public laws except that one. That's the first time I've ever seen it. So let's look at the next one. 18 U.S. Code 1348. Securities and commodities fraud. Whoever knowingly executes or attempts to execute a scheme or artifice to defraud any person in connection with any commodity for future delivery, or any option on a commodity for future delivery, or any security of an issuer with a class of securities registered under Section 12 of the Securities Exchange Act of 1934, which is 15 U.S.C. 78L, or that is required to file reports under Section 15D of the Securities Exchange Act 1934, 15 U.S.C. 78OD, or to obtain by means of false or fraudulent pretense, representations, or promises any money or property in connection with the purchase or sale of any commodity for future delivery, or any option on a commodity for future delivery, or any security of an issuer with the class of securities registered under da 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 da. To obtain. So when you use that Social Security card to obtain money, property, labor, or services, and that is an extension of credit, and they don't accept it as an extension of credit and deny you your use of credit, that is a misapplication. You guys understand that? It's a misapplication. Let's see. Visa and MasterCard to be treated as credit. And so, as I've been saying, everything's about the Postal Service. This is a World Global Postal Trust. The World Global Postal Trust, and under the Postal Service, USPS.com, notice it's a registered agent right there, okay? And it says what forms of payment are accepted. Can I use debit cards at retail? Remember, we spoke about retail earlier, right? It's because you give them all the details, right? Okay, that's a misapplication of the details by them. Debit cards. Oops, let me blow this up so everybody can see this really good. Debit cards are accepted for all services except for passport fees to the State Department. Debit cards may be used to pay the U.S. Postal Service processing fee. Cash back allowed in $10 increments up to $50. And it says here as a note, if a checking or debit card has a Visa or MasterCard logo on it, then it should be treated like a regular credit card. So you tell me if I'm the insane one. Greetings, Kingfish.
How you doing, Keith?
Good, good. How you doing?
I'm just doing fine. Happy New Year's. Happy New Year's to everyone. Yeah, I'm here in attendance.
So what's your experience with credit and debit and all that? You got any stories to tell us, or some kind of even abuse or anything that you'd like help in trying to get figured out?
Well, actually, I've been implementing and standing on the trust in regards to enforcing like a lease or utilities. But what I do find is this: government agencies are a little more honorable than corporations.
Absolutely, I'll agree with that.
Yeah, because I've witnessed and experienced in a court situation where the case was placed into a trust, and I gave instructions to the trustee that was within the court system to take that case out of general and redeposit into special.
Correct.
And He actually did it.
It's called a reversion of credits because
Yeah,
you deposit them in the wrong fund.
exactly. And so the reason why I noticed it was because they switched the court date one day over. So that was the first indication of, being honorable. And then, but then the public, everyone was acting, the attorney, the judge, everybody was acting in the public. And it appeared that I lost. But in the private, it was full honorability.
Yep.
Which,
and that's what I'm working with in this the dismissal on the failure to appear for jury duty. They still went ahead and assumed personal jurisdiction and placed the costs are taxed to the defendant. So I've got to write them another little note and let them know, hey, if you're going to tax the cost to the defendant, then here's how you route them. Basically what you said, take them out of that general deposit or general fund and redeposit them specially, and here's the trust number.
exactly. Mm-hmm.
So, and that's what Harry Nuts down there all flipping about, signature and that. If you're going to be out there accepting them forms, you can most certainly qualify the signature with a number. It's a sales agreement saying that you are buying or selling something, and under 19 CFR 149.3 data elements, it says you can use a widely recognized commercially identifiable number in lieu of the name and address. And people just don't catch on to that verbiage and stuff, and it's just pathetic. You can sign with a symbol. You can sign with a stamp. You can sign with a thumbprint. You can sign with a dot. You can sign with an X. It's your signature. That's all you got to do. And you can change it every fucking day. Just like you can change your name.
Yeah, I agree. On the public side, I use one form of identification, and on the private side, I use a different form.
Yep, that's you got all kinds of actors and performers that use dual citizenship to get dual passports in different names. People just need to learn how to use the instruments.
But I do have a question in regards to utilizing the postal judiciary in enforcing, certain issues. And so, especially in regards to the trademark, because 2024 will be the enforcement of that issue.
Right, and that goes to the copyright and stuff. And like I explained last night, what they did was they took a name that you have all rights in, and that was given by mom, and that name, both the given name and the family name were then translated to a legal name. And what that does is that's a creation of the state. But as a young man coming up into age of majority, if I decided I wanted to create a legal name, I could do any name I want. But that's also to say if I wanted to choose my own name as the legal name, I could do so. But the state already made a claim on it. They didn't have a right to make that claim. And they only did so by attaching a number, which is the integrity that we talked about earlier. It's an integer. It was an enumeration, and they attached that to the legal name. So it's a matter of salvation of the name and merging it with a new name, now operating under another date. Does that make sense?
Okay, well, let me ask you this: when when that name was claimed by a government agency, wasn't it claimed in general deposit?
Correct. And that's the point I'm making. You can still claim that legal name, but like you said, you got to remove it from that record. That's a general public record, and you got to place it into a special record.
Right.
And that's removing from the trust into a private trust, the public trust into a private trust. Same thing.
Right. Yeah. So that's basically, the perfection of that has increased. Because they don't give us a manual on this stuff, so we have to kind of learn it. And I appreciate your due diligence in, exposing a lot of the information that you have been broadcasting. And so now it's time to put all of these puzzle pieces together and moving forward with because now, mark my words. First of all, we're coming up on the 100th year anniversary of the Great Depression. So what does that mean? Well, what it means to me is that history is going to repeat itself. It's already starting to repeat itself, very slow and methodically. So for those who are not prepared, they may suffer tremendously by 2030 or 2032. Because that Great Depression.
You basically got 6 to 8 years to set your children up, folks. And if you ain't got yourself set up first, you're going to have a problem. And it's really not hard to set yourself up if you know how the system operates with the double book entry, because the credits are already there. And oops. Okay, he's back. And the credits are already there, particularly if you think about your mom and dad's estates that are still in probate. If they passed on without a living will and didn't correct that record, it's still in probate. So you can still go back and get that too.
Mm-hmm.
And that's your right of legacy and right of inheritance. That's your legacy heir. That's the two become one. Your dad provides the legacy, which is the story, the spirit that passes on, and then the inheritance is your material Mother Earth. So that comes from your mother, and that's all the material possessions that come along. That's why you get the dowry from the mom.
So what if the father's still living?
If the father's still living, same with the mother. If the father and mother are still living, they can actually write a statement testimony, heralding, hey, we forgot to let everybody know this is actually a child of God. That's about it. It's basically letting them know that, hey, we forgot to put him in the Bible, and let you know that that's the foundation of your common law, and that's his access to the common law, despite your statutory codes and your executive orders in courts of law.
Okay. Well, I'm gonna have to say good luck on that one with my dad.
Yeah, I would have to say the same here. It's like I said earlier, and the guy that we reviewed the video on, he agrees. Everybody's been indoctrinated. These people don't know this stuff. So it's a matter of us learning it first and then learning how to solve it by educating them. And, that's usually just in our own case and according to our children. So then when we try to press it in recovering our father's estates and our mother's estates, that's going to be even more difficult. So just a matter of process and getting doing it repeatedly so we get better and better at it. And that's the awareness that comes about it.
Yeah. Now, I believe that in addition to all that, creating organic evidence or documentation.
Right. Journal. That's that's why I've got 18 profiles on this metaverse thing here for journaling, is because I want to cover different topics, and I want to make sure that in these topics I'm speaking on my personal firsthand experiences. So it's going to be a journal of my experiences throughout the life, through my researches and everything. And it's just a matter of journaling my path of becoming more and more aware by exposing more and more of the things that I didn't know before. That's all it is. That's the true benefit, people, is knowledge. If my people are destroyed for lack of knowledge, then the true benefit would be the knowledge that helps them build themselves back up. So, and real quick here, Yeshua's Ministries, is there a correct way to approach probate? Probate means that nobody gave their living will. And under Scott versus McNeil, it says that the court of probate has no jurisdiction over the estate of a person who is in fact alive. And that's Scott versus McNeil, McNeal. And I would put that in a search engine with Library of Congress. And that will come up. And you'll see they talk about that left and right. The court of probate has no jurisdiction over a living being.
I now I went into probate, attempted to litigate this situation I mentioned earlier in regards to a court issue. But what I began to realize, and the probate judge said it a couple of times. She said, "This is a public court." Because I said,
yeah, you got to do that in private.
But I said to her, but I requested to go into chambers, and you deny me. She said, "This is a public court." So I just kind of read through the lines and kind of understood that at least on that public side of things, if you appear in the court, of course, we know that's public, but they gave me the impression that they just didn't have the jurisdiction that I believed that they should have had. It's a public agency. It's nothing private about it.
Well, it's a matter that they took a private journal. See, that's that mom's prenatal record from the private practice doctor. They mixed that private journal as if though it was a general journal when she went to the hospital and had a baby. So now they've got a private journal that was entered into public. Now it's a general journal. The birth clerk comes in, has them fill out a document known as a statement of live birth and sign as informant, and now it creates a general ledger. That was the first deposit that needs to be transferred from the general deposit to a special deposit.
Okay, so
that's why these people are doing the birth certificate stuff.
How about this? That also perhaps that they're really the probate court is really a front for the state registrar being the actual probate judge.
Correct, because it's all done through the Bureau of Vital Statistics. That's what they establish when you're born, is the state's vital statistics jurisdiction, and it's exclusive to each individual because each individual has a different name and number. And so what they're doing is they're creating a new record, and that itself is a jurisdiction exclusive of all others, and it's a private probate jurisdiction.
Mm-hmm. Yeah, it's kind of like no different than the DMV leasing or renting the court to prosecute those who violate the DMV code.
Yep. And I don't know what they're complaining down. I don't mind it so much because I can at least tell what you're saying, but you are kind of borging a little bit. If there's anything you do about your mic, people would certainly appreciate it.
I didn't know if that was my mic or yours, because I know I hear
Yeah.
static.
Yeah, it's from your end.
Oh, okay. Well, I'll mute out. And
All right. Well, and we're getting ready to end it anyway, brother. But I certainly appreciate you coming up and speaking. I would certainly love to have you again. And if there's anything you want to say before we cut out, please feel free to do so now.
yeah, sure. I'll try to participate. I just have to coordinate the times that you're going to be on, and you know, this is
Well, I'm going to try. Yeah, I'm going to try to be on at 9 p.m.
Okay, all right. I'm in California, so yeah. So.
Yeah, it would be. This is 9 p.m. Central, so it would be what 7 p.m. Yep, 7 p.m. your time.
Oh, okay.
So, all right. Well, again, I thank you for coming up, brother. And with that, folks, you guys know me. I love you. I don't give a rat's ass whether you love me back or not. And that's to say, I don't care that you hate me or not. It's up to you. So in the meantime, may God bless you and have a good night.